Hello everyone, welcome to another Athena Studies knowledge clip. This time we're going to talk about legal strategies and we're going to have a quick summary of what legal strategies are and when can we use them. Let's go. But before we begin, feel free to join us in our end-term trainings to see a structure based on past exams where you can learn the most by asking your own questions. And you can also have the 24/7 WhatsApp aid, so you can ask your own questions whenever you want before the exam to make sure that you cover every single topic. So, let's begin. Reducing agency costs. Remember that reducing agency costs is one of the main goals of corporate law. We want to reduce agency costs so that business operations do not suffer from these kind of interference. And to do so, we can use legal strategies. Legal strategies are a generic method of deploying law instrumentally in a functional way. The function in this context being to mitigate the vulnerability of principals to the opportunism of their agents. Yes, this is the definition. But you can also forget about it. What we want to do is we want to prevent the agents from working for their own benefit. What do we want? We want the agents to work for the principal's benefit. So, we want the directors, for example, work for the owners of the company's benefit, so shareholders' benefit. To do so, we can follow two different types of legal strategy. The first one is regulatory strategies. Regulatory strategies are prescriptive, meaning they dictate substantive terms that govern the content of the principal-agent relationship, and they also tend to constrain the agent's behavior directly. The second one is governance strategies. Governance strategies seek to facilitate the principal's control over the agent's behavior. Let's move on and take a deeper look. We heard about regulatory strategies already. We said that we want to constrain the agents. So we constrain the agents by commanding them not to take courses of action that would harm the interests of their principals. So, how can we do this? First, we can have some rules which require or prohibit specific behaviors. And second, we can have general standards which leave the precise determination of compliance to the adjudicators after the fact. Second, we have another type of regulatory strategy we can use, which is affiliation. Affiliation is regulating the terms on which principals affiliate with agents rather than actions after the principal-agent relationship is established. And this is also related to the exit strategies. Exit opportunities for principals, such as avoiding a shareholder to the right to sell her stock. This allows principals to escape opportunistic agents. And in relation to exit strategies, we can talk about two different rights. The first one is right to withdraw. The right to withdraw is, for example, awarding an appraisal right to shareholders who dissent from certain major transactions, such as mergers. And the right to transfer, the second one, is the right to sell shares. These ones are quite important, for example, after a merger or after a takeover. Let's move on. We have another category of strategies we can use. These are incentive alignment strategies. They straddle the boundary between regulatory and governance strategies, and they try to align the interests of the principal and the agent. This time, we don't have rules or we don't have consequences which punish the agent, but we have consequences which reward the agent. So, the first one is trusteeship strategy. And in trusteeship strategy, we want to ensure that an agent will not obtain personal gain from disturbing her principal. Second, we can follow a reward strategy. Here, we reward the agents for their successful advancement of the interest of their principals. There are two subcategories we can mention about the reward strategy. The first one is sharing rule. The sharing rule motivates loyalty by tying the agent's monetary returns directly to those of the principal. And the second one is the pay per performance approach. And in this, an agent, although not sharing his principal's returns, is nonetheless paid for successfully advancing her interests. Here, we can mention two different rights. The first one is appointment rights, and this refers to the power to select or remove directors. And the second one is decision rights. Decision rights grant principals the power to initiate or ratify management decisions. These two rights are granted to shareholders, of course, the owners of the company. Let's talk about disclosure a bit. Disclosure is the process of making facts or information known to the public, but in this case, known to the shareholders specifically, because the shareholders need information to decide whether they want to stay in the company, stay in the corporation, or they want to exit. The first one is prospectus disclosure. Prospectus disclosure forces agents to provide prospective principals with information that helps them to decide upon which terms, if any, they wish to enter the firm as owners. As the name suggests, it's prospective. So this information is provided to shareholders which are currently not shareholders, so prospective shareholders. And then we have ad hoc disclosure, in addition to periodic financial disclosure. So we mention them together because these are on demand or action specific or event specific. So they allow principals to determine the extent to which they wish to remain owners or rather exit the firm. In relation to the strategies, disclosure can be used in several different but complementary ways. And these strategies specifically are governance strategies. Disclosure allows principals to assess appropriate intervention tactics. And if principal's approval is sought, can improve the principal's decision. Disclosure of those serving in trustee roles serves to bond their reputations publicly to the effective monitoring of agents. Disclosure is a very key part in protecting the shareholders' interests. There is definitely more to know about the legal strategies and how they work in a corporation. But for this knowledge clip, this was it. Remember, you can join us in one of our end-term trainings for more theory, more examples, and practice questions, which is structure based on past exams. Thank you for joining us and have a nice day.